Welcome. I'm Gail Williams, Director of Metro Fair Housing Services. Welcome. We are going today to be talking about the fair housing rights for people with disabilities. First, I need to say thank you to the Henry County Department of Community Development, and I have to thank Shannon Sanyo, its director, for continuing to partner with Metro Fair Housing Services to provide the fair housing education needs of all of Henry County citizens. So we're going to be talking today about a powerful federal act. It is our national policy against housing discrimination, and we're going to be talking about focusing on all of the rights under it, but particularly the rights of people with disabilities. So we have three objectives here today. To first of all, help you understand what the rights and protections are under the Federal Fair Housing Act. Secondly, we're going to talk about how do you recognize discrimination and what is it that you can do to report it if you feel like you've been discriminated against. And thirdly, as we move through the presentation, we are going to talk a little bit about how housing discrimination is still being manifested right now today, both nationally and right here at home in the state of Georgia. First, I'll just say a quick word about Metro Fair Housing Services. We are 50 years old this year. We're a private, not-for-profit civil rights organization, but our main purpose is to prevent housing discrimination in the metropolitan Atlanta area and throughout the state of Georgia. We do that basically by three pieces of business. First, education and outreach, which you're participating in here today. And education and outreach means that we make sure the general public know what their rights and protections are, and we also make sure that housing providers know what their responsibilities are. Our second piece of business is complaint intake and counseling. So we accept allegations, complaints of housing discrimination, basically from metropolitan Atlanta, but we also receive them from other parts of the state of Georgia. And we process those complaints. We'll talk a little bit about that as we move along. And then thirdly is enforcement. Enforcement means that we have standing to actually take a look at housing providers and see whether or not they're complying with the law. So I'll say a little bit about that later on as we move forward. So when we're doing these live sessions, we actually have a little fun with the audience. Of course, I'm in a situation here where you're not right here with me, but we always ask everybody, so what do you think housing discrimination is? And the answers are as varied as people who decide to answer it. But it is an amazingly simple definition. Most people think it's kind of complicated, but basically housing discrimination is defined as any attempt to prohibit or limit free and fair housing choice. That's about as simple as it gets. A person or an entity who's violated a fair housing statute is considered to have committed housing discrimination. So the way we got here, we had a pretty long legislative history as well as a judicial history, meaning what happens in the courts as to how we got down to the passage of the act. But we're going to go just through some highlights in that history because actually everything that happened from the 13th Amendment down to 1968 when the act passed, all of those instances are important historically, but they are classes in and of themselves. So the Federal Fair Housing Act, it actually was a Civil Rights Act of 1968. It was passed in 1968, exactly 7 days after Dr. King was assassinated in Memphis. It was amended again twice, but as it stands amended in 1988, this is the best way to understand it. Because when we start talking about protected classes and things start sounding a little legalistic, often, people get lost. The best way to understand it is this. It is based on the premise that if you're in this country, you deserve shelter. Doesn't define what kind of shelter, but basically that shelter is a human right. That was the basis of it. So it basically says you should not be denied a housing opportunity. And if you are denied a housing opportunity, if you can afford that housing opportunity, you shouldn't be denied it just because any of your 7 basic characteristics. And they're broadly defined so as to be inclusive. So basically it says you should not be denied it because of your race. You should not be denied a housing opportunity because of the color of your skin. You should not be denied it certainly because of the religion that you practice. You should not be denied it because of the country you're from or your national origin, and sometimes that's designated by the language you speak. You certainly should not be denied it because of your sex or gender, and that covers sexual orientation and gender identity. You certainly should not be denied it because you have a disability, and you should not be denied it because of your familial status, meaning you have persons in your household under the age of 18. So discriminating against families with children is strictly forbidden. So in the state of Georgia, most people don't know, but Georgia has its own fair housing law. And it has the 7 basic protected classes of protected characteristics as in the federal law. And it is substantially equivalent to the federal law. So this powerful law, the question is, how does it get enforced? Because a law is only as good as its enforcement. So this federal law is actually administered by 4 types of agencies. At the federal level, U.S. HUD, Housing and Urban Development, is responsible for enforcing the law. And then, of course, the Department of Justice is responsible for enforcing the law. Usually at state and local levels, there are organizations we call FAPs. They get Fair Housing Assistance Program money, and that's why they're called FAPs. We actually have a certified FAP here in Georgia. It's the Georgia Commission on Equal Opportunity, and that agency enforces Georgia's state law. That law, as I said, it is substantially equivalent to the federal law. And then you have private fair housing agencies like Metro Fair Housing Services. We compete nationally for this funding because this is the only money that the federal government puts into private enforcement of the Fair Housing Act. And that's under the Fair Housing Initiatives Program, or FIPS. So we call those local agencies FIPS. So what is it that you do? If you feel like you've been discriminated against, exactly what is it that you can do about it? There are 2 processes. There's an administrative complaint process, wherein you have 1 year from the last alleged act of the discrimination to file a complaint. And you can file it with any of those agencies I talked about, HUD, DOJ, the state agency, or a private fair housing organization. You have 1 year. So for the circumstances of that complaint, you cannot file, you've lost the opportunity to file after 1 year. Then secondly, this is why this statute is so powerful, the private right of action, meaning you don't have to exhaust any administrative processes. You can go straight into federal court, sometimes state court, and file a lawsuit against a person or an entity who you feel like has discriminated against you in housing. You have 2 years from the last alleged act of that discrimination to file that complaint. Now, we caution you, just because you have the right to file it doesn't mean you should run around just filing lawsuits. Certainly you should talk with an attorney or talk to one of those 4 agencies I discussed, and you need to make sure you have a sound case, because if you file a lawsuit and you lose the lawsuit, then you set up what we call bad case law that the rest of us have to live with almost in perpetuity unless the conditions of that lawsuit get overturned. So why do we need fair housing? What is the big deal? Well, because housing is so core to everything, to all people, everybody needs it. And housing correlates directly to your access to opportunity. It certainly determines where your children go to school unless you got the money to send them to a private school. It could determine your health care options, your job options, A lot of people live on food deserts basically because they are confined to the areas that they live in and they don't have healthy choices. Your transportation opportunities, certainly your community amenities and your municipal services are all determined by where you live. So I have a lot of housing providers tell us, you know, that fair housing stuff, that's just for renting. No, it is the law. It covers all real estate related transactions. But it is the law. It is not optional. And how about it helps housing providers avoid liability? Moreover, how about it is the right thing to do? Because when we prejudge people because of any of those protected characteristics, we just make decisions about them because of their race, their color, the language they speak, or because they have children or they have a disability. We prejudge them. Well, unfortunately, we all do, and mistakenly. And how about fair housing is good business? Because diversity is certainly the future, and diverse neighborhoods are thriving neighborhoods. So there are 3 key laws that relate to discrimination based on disability. We're talking today about the Fair Housing Act. It covers virtually all housing with a few exceptions. We're not going to go into Section 504 of the 1973 Rehabilitation Act, but it basically covers recipients of federal financial assistance, and HUD has lots of regulations about it. It does not apply just to landlords who only receive Section 8 certificate or voucher funds. Then there's, of course, the Americans with Disabilities Act. Title II of that applies to housing operated by state and local governments, and it's similar to 504. And then Title III applies to the places that serve the general public in the housing space. That includes like the rental offices, but it does not cover the housing itself. So we're going to focus here on the disability protections because we know that in this country, just in 2023, when the Trends report came out about complaints in this country by NAFA, the National Fair Housing Alliance, just over 33,000 complaints were filed across the country, and that's from all those agencies. That's complaints from HUD, DOJ, private, public enforcement agencies, everybody. That actually is a very, very small number. NAFA projects that there are about 4 million instances of discrimination that happen in this country every year, and that's just in the rental market alone. So less than 1% of the instances of discrimination ever get reported. And that's because people don't know their rights, or they're just afraid to come forward, or they feel like, well, if they don't want me there, I don't want to be there. That is not the attitude to have. The message here today is know your rights and be able to act upon them. So the disability definition under the statute is intentionally broad. It covers a physical or a mental impairment that substantially limits one or more major life activities. And major life activities broadly defined. It's just everything it takes to take care of yourself. Just performing everyday manual tasks, walking, hearing, seeing, breathing, learning, working. Again, broadly defined and intentionally so. So the law says if you have a disability, you have 2 ways to enjoy the property the same as people who don't have a disability. First, you can request a reasonable accommodation. And that's where you're asking the housing provider, I need you to make some changes in your policies, your rules, your services, so that I can be afforded the opportunity to enjoy the dwelling. And that includes changes that you might need in the public or in the common use areas, not just in the housing alone. And most people don't know with disabilities that they can ask for those changes. We have a lot of, almost all of those 33,000 complaints I talked about in the country were actually over 70% of them came from people with disabilities. The second highest reason for complaining was race. That has flipped over the past several years. Originally, the highest number of complaints was based on race and then disability. But at this point, we see a lot of complaints because people have animals. They have service animals or they have emotional support animals, and they make requests, and they're often denied. But there's a standing guidance on that we use for years, FHEO 2013. That was replaced in 2020. And now the guidance is called Assessing a Person's Request to Have an Animal as a Reasonable Accommodation under the Fair Housing Act. It basically says there are two types of assistance animals. They're either service animals or they're support animals. And it just provides what best practices are. It helps the housing provider assess a request for a reasonable accommodation, and in particular, the type and amount of documentation a housing provider may ask for related to an accommodation when you have a request for a support animal, when there is a request for a support animal. But the law says those requests, for them to be valid, need to be necessary and they need to be reasonable. So to show that a requested accommodation may be necessary, there has to be a relationship, an identifiable nexus between the requested accommodation and the individual's disability. I'll give you a quick example. We had a complaint from a person who was moving here. They ported from Texas here to the Atlanta area in public housing, and out in Texas they had a 2-bedroom unit. When they came here, the housing authority said, well, you only need a 1-bedroom unit, it's just you. But this complainant alleged that she had health reasons why she had machinery and she needed a healthcare worker to assist her. The housing authority denied her that request. She filed a complaint with us, but under our investigation, we found that we couldn't verify the disability that she was claiming and the need for the other bedroom. So she was not very happy. But as it turned out, we found that the request really was because she kind of had her other family coming. Her grandchildren were going to come with her, and it was important that she have a bedroom for them. It really was not about having a disability. So there really has to be a connection between what you're requesting and your actual disability. And any accommodation, it won't be considered reasonable by the housing provider if it constitutes a fundamental alteration of the housing provider's program, or it's an undue financial and administrative burden. So many housing providers will claim that that's going to cost too much. Whatever you're asking me for, that's too much. No way we're going to be able to do that. But if we investigate it, we have to take a look at, is it really an undue financial burden? We have to take a look at the financial resources of the provider, how much is the accommodation really going to cost, and what are the benefits of it. But most importantly, the housing provider has to offer an alternative. There has to be the availability of a less expensive alternative accommodation that's going to effectively meet that applicant or that resident's disability-related needs. That has to be considered. And often housing providers don't do that. They just tell you no and turn you down. And a lot of people accept that because they don't know that their rights. As I said in the definition, a lot of people feel like if I have a disability, it has to be something that's obvious, something that people can see. But the law covers physical and mental disabilities. It covers paralysis, blind and low vision, deaf and hard of hearing, cancer, heart disease, etc. It certainly also covers mental disabilities that clearly may not be obvious. It covers depression, bipolar disorder, schizophrenia, mental retardation, and other developmental disabilities. The protection, however, does not include current illegal drug abusers. It does not cover juvenile offenders or sex offenders, and persons convicted of the illegal manufacture or distribution of a controlled substance. That law, as passed and amended, does not include those things under the disability protection. However, if you are a current drug user, then if you are actively enrolled in a program that helps you address that disability or helps you address that addiction, then you can be considered covered under the disability definition of the law. Another thing, the definition of disability does not include people who objectively pose a direct threat to the health or safety, or whose tendency would result in substantial physical harm to the property of others, are not covered, unless that threat can be eliminated or significantly reduced by a reasonable accommodation, again, providing an alternative. We, of course, have a lot of complaints. Over 60–70% of our complaints are also disability related. But we did have a complaint from a gentleman who, it was from someone representing him. He was being evicted because they said, the housing provider said he is a clear threat. He's a threat to the safety of our office workers, other people in the building. When we investigated on his behalf, we found out that, in fact, he was supposed to be under medication. He was supposed to have an assistant, and he had not had any of that for the past 6 to 9 months. So our director of enforcement negotiated with the housing provider to hold off on the eviction and go ahead and let us get him his proper medication, let us connect him with the right health aid assistant that he was supposed to have. And when we did that, all of the acting out stopped. He was a perfect tenant and provided no threat to anyone's health or safety. So we were able, that it was in fact an accommodation that we were able to get for him, and he was not evicted. So a lot of housing providers, of course, want to use the direct threat protection to get rid of people. But the law says that you can't just exclude people because you have some basic fear or speculation or some kind of stereotype that you're holding about people with disabilities in general, but that you have to rely on some individual assessment, and that it has to be based on some reliable, objective evidence, like current conduct or recent history of overt acts. You can't just speculate and say, oh, that person is a direct threat, I need to throw him or her out of my housing. So when we take a look at those housing providers that are claiming a direct threat, we kind of have to look at some things. So we look at everything: the nature, duration, and severity of the risk, what's the probability that injury is going to actually occur, and then of course, whether or not there's been any reasonable accommodation offered that will eliminate the direct threat. So the Fair Housing Act basically says that if a disability is obvious to the housing provider, they are obligated to provide the reasonable accommodation or work with you to get it taken care of. But what about the case of invisible disabilities, which obviously, clearly, there are lots of examples. So there is a old case, 1996, Jankowski, Lee and Associates versus Cisneros. Cisneros at the time was the Secretary of U.S. HUD. But this was a case that was all about a parking space. In the end, the judge said, if the landlord is skeptical of the tenant's alleged disability or of their ability to provide the accommodation, it is incumbent upon the landlord to request documentation or open a dialogue. So it turns out that this particular gentleman, the landlord said, well, he jaunts in here every morning and he, talks to the ladies and goes on out the door, but he wants a parking space closer to his unit, and he doesn't need a parking space. He doesn't need a handicap parking space. And they couldn't settle it, and this ended up in court, obviously. But as it turns out, the gentleman did have a disability. It was not obvious, and it onset periodically at different times. It wasn't always evidence. He did clearly have a disability that he had provided documentation for, and the landlord kind of refused it or overlooked it. But I'll let you know, of course, the landlord lost that case. So the Fair Housing Act, it has specific provisions about when you can ask about a disability or ask somebody to provide documentation for it. In a lot of instances, they should not be asking for documentation of the disability. It should be focused on the accommodation request. But the Fair Housing Act says you can ask about the disability in two instances, where the disability is a requirement for eligibility, as in, for example, HOPWA housing. Housing for people with AIDS, they have to actually demonstrate that they have the AIDS virus in order to be eligible for the housing. And then in the instance where the disability is necessary for a preference, a lot of times the housing provider will have accessible units available. And in that case, in order for you to qualify for those units, you would have to provide some documentation of your disability. So we get asked all the time by housing providers, so what's the process for reasonable accommodations? What is it that you must do? But the law says there's no specific or required process for making a reasonable accommodation request. But the accommodation request, it can be made verbally or in writing. Now, we counsel people not to just state the accommodation verbally. You can, it's acceptable under the law, but too many instances will get into a situation or actually be in litigation, and there'll be the housing provider is going to say, they didn't tell us, they never said a word. And of course, the complainant is saying, oh yes, I did, I told you a lot of times. And the judge got no way of verifying it. So we train people, put your request in writing. We'll assist you in putting it in writing if we need to. So, and what you do request, you don't have to say this is a reasonable accommodation request, because most people don't even know what that is. But they just need to ask for what it is that they need. And there is an obligation to make an accommodation even when one is not actually requested, if the need is apparent. If the housing provider can actually see the disability and see the need for it, the law says you need to approve that accommodation. You do not need to deny it because the need for it is apparent to you. And of course, you cannot ask for confirmation of a disability or of the need for accommodation if the disability or the need is obvious. Second way that people with disabilities can enjoy the property as persons who don't have a disability is by requesting a reasonable modification. Now remember, an accommodation was a request for a change in policy or services. A reasonable modification under the Fair Housing Act is an actual structural change. So we're talking about building a ramp or putting grab bars in a bathroom, for example. And the law says that the housing provider, the housing owner, may have to pay for those changes. And the changes could be required to comply with certain laws. So in the case of private housing, generally, with no federal money involved, the person making the request for the reasonable accommodation most often is to pay for that. But of course, it could be a case where, based on the funding, especially if there's federal funding involved, where the housing provider is supposed to already make those changes. So under the Fair Housing Act, the reasonable modification requirements, it's a requirement to permit, at the expense of the person with the disability, reasonable modification of existing premises. If the person is to live in the unit, the housing provider cannot require removal of any modification in a condominium or require removal of any modification in a public or common use area, or require removal of a modification on the inside of a unit unless it would impair the use of the rental unit for someone else. If the modification would impair the use of a rental unit by someone else, then a reasonable deposit to cover the possible restoration costs of the interior of the unit is permissible. And of course, we get into a lot of squabbles about what is permissible, because the housing provider will sometimes be tacking on some more cost in order for a modification to be removed when the person is moving out. And of course, under reasonable modifications, the same type questions about the disability and the housing provider's inquiry about the disability are permitted. But the key elements of a modification request are the need for the modification has to be known to the housing provider. Again, a lot of squabbles about that. A delay in approval can also amount to a denial, because a lot of times housing providers will say, well, yeah, let me get back to you. And then a lot of time passes and nothing is said or done. So that delay can be considered a denial, and the housing provider may only refuse permission for a reasonable modification if the modifications are not going to be made in a workmanlike manner. And of course, in some instances, there are permits required depending on the modification and where you are. So necessary permits have to be gotten. If they are not gotten, the housing provider can refuse permission. And sometimes a notice that a reasonable accommodation may be necessary in that permitting process, addressed to a zoning official to allow some modifications to be constructed. Again, that just depends on what you're doing and where you are. So the big no-nos for reasonable modifications. A housing provider may not charge you a fee. So a lot of times a housing provider say, oh, sure, I'll let you put in that ramp, or I'll let you put in those grab bars, but you're just gonna have to pay administrative fee for doing that. They cannot change the plans. They cannot require you to have insurance in order to do the modification, and they can't dictate to you who the contractor is. But just remember, but they can say and monitor that it's done in a workmanlike manner. They cannot dictate the type of construction, and they cannot unnecessarily delay approval. So most folk don't know it, but under the Fair Housing Act, there are design and construction requirements actually in the act. If you take the class on design and construction, you leave there with a 2-inch binder and you're there for 8 hours. But there are design and construction requirements with basic accessibility features for people with disabilities. And they apply to buildings that are designed and constructed for first occupancy after this magic date, after March 13th, 1991. Often we will ask complainants, we'll ask them just to see if they know when the building was constructed. And that's the reason we're asking. Of course, we have to do our research to find that out ourselves, but we do ask sometimes, do you know when the building was constructed? These basic features apply to buildings with 4 or more units. So multifamily units, all of the units have to meet those basic accessibility features if the building has an elevator, and then only the ground floor units have to comply if the building does not have an elevator. And your best resource for anything accessibility related is www.fairhousingfirst.org, the very best resource. Any and every question you have, free trainings, anything you need to know. So those basic 7 key accessibility elements are as follows, and it's very important to know because we have all of this development going on around us. Of course, we have an affordability problem with the rents being high, and people just assume that if something is brand new and sparkling and looks good and modern, that it's supposed to have everything it needs. In our testing, we find that many of these newly constructed multifamily buildings don't even comply with the 7 basic key elements of accessibility. First of all, there has to be an accessible building entrance on an accessible route. The test, of course, is a person in a wheelchair. That means a person in a wheelchair needs to be able to have an accessible route at the entrance. Have an accessible building entrance, and it has to be on an accessible route. You're supposed to be able to get from the parking lot or the sidewalk into the building. There have to be accessible public and common use areas. There have to be usable doors, meaning doors with latches, not round knobs that everyone isn't able to grab. There has to be an accessible route into and through the covered units. Remember, we talked about them being all of the units or just the ground floor units. Then, of course, all of the environmental controls have to be in accessible locations. So the light switches have to be a certain height from the ceiling and from the floor. All of the environmental controls have to be where a person in a wheelchair can reach them. And then lots of questions about this. Yes, there have to be enforcements in the wall for grab bars. The law doesn't say you have to install the grab bars, but the reinforcements have to be there. So if a person requests them at a later date, they can be installed. And that is a big problem because sometimes the walls have not been reinforced for grab bars. And there have to be usable kitchens and bathrooms, meaning turning radiuses, ability to get in and out of kitchens and bathrooms and use all of the facilities have to be accessible for a person in a wheelchair. Most people have no idea that that is the case in new construction multifamily. So, some examples. What is discrimination based on disability-wise? So we got some actual examples of complaints and of filings in courts. Nice case down in Orlando a while ago. This apartment was denied to prospective tenants because they were both visually impaired. It was a husband and wife who moved to Orlando from New York, and the landlord said they had to live on the second floor, and they would be required to have a sighted person living with them or a CNI dog. So they filed a complaint and said, no, we want to live on the second floor. We want to have a view. As it turns out, they were not blind, but they were low vision. They were visually impaired. But again, there was no evidence of them, as the landlord claimed, falling down the steps or causing fires or anything like that. That went all the way to trial without a conciliation, so the jury awarded compensatory and punitive damages after the trial. That means damages high enough meant to punish, because the landlord was steering those persons based on their disability. There's another example of HUD charging the Bank of America with discriminating against home buyers with disabilities. HUD alleged that the Bank of America imposed unnecessary and burdensome requirements on borrowers who relied on disability income in order to qualify for their home loans. And then they required some borrowers to provide even physician statements in order to qualify for their mortgage loans. Again, strictly prohibited under the fair lending requirements of the Fair Housing Act to require that of persons with disabilities when they were not requesting that kind of documentation for equally qualified borrowers. Discriminatory zoning, good example. Several years ago, Atlanta Journal-Constitution did an article about their look around the state of Georgia, and they said they saw a lot of discriminatory zoning, especially based on disability around the state of Georgia. I wish I had that research ability to take a look at that. But actually, this was a Department of Justice. They filed against a local jurisdiction because they had an ordinance that prohibited persons with disabilities or people with a specific kind of disability, such as a mental illness, from locating in a particular area of a city while allowing other groups of related individuals to live together in that area. So The joint statement on reasonable accommodations and the joint statement on modifications between HUD and DOJ are references, and we often have to point housing providers to those regulations. What's actually prohibited? What is actually illegal that housing providers cannot do under the Fair Housing Act? So this is just a general bulleted list, but in general, they cannot refuse to rent or sell a dwelling after a bona fide offer has been made. Again, that's if and only if. The reason for that refusal is because of one of your 7 protected characteristics. They cannot discriminate in the terms, conditions, privileges, or facilities, meaning changing up the requirements for the housing, let's say based on who's in front of them. If I'm renting a 2-bedroom apartment, the first folk to come in the morning, I say, hey, no problem, you need 2 bedrooms, we got 3 or 4 available, let me show them to you. As a matter of fact, if you want to live here, you know, the first month is free, don't worry about your credit score, da-da-da-da-da. Second set of people come in, and they also are looking for a 2-bedroom unit, but they're told, well, you know, we really don't have anything available. Maybe you want to come back in a month or so and see me, but when you do come back, just know that, you know, we don't, you know, you're going to have to pay first, last, and security. Your credit score is going to have to be 800, you know, all of these terms and conditions. You need to be on your job this long. You are quoting different terms and conditions for the same housing unit based on who's standing in front of you. Strictly prohibited under the Fair Housing Act. If that differential treatment is because of one of their protected classes. And of course, you can't lie about availability. Either the place is available or it is not. Consistent information should be provided by the housing provider for the same housing opportunities. And you can't engage in any conduct that otherwise makes the housing unavailable. Most folk don't know there are advertising restrictions under the Fair Housing Act. So you should not be making any statement or advertisements that indicates any preference if it appears that that preference or that limitation seems to follow along those 7 protected classes. Don't know how many people know what Meta Platforms is, but I guess Facebook, it was Facebook previously. Everybody kind of knows what Facebook is. I'm a dinosaur, I'm not on Facebook. But they were allowing advertisers to pick and choose who they could advertise housing to. And their platforms, we call it bias or discrimination by algorithm, but their algorithms were set up. So if the housing providers say didn't want particular about children being in their housing development, they could restrict the advertising and focus it on, say, single people or young people or couples that did not have children. Again, the prohibited practice there was discriminating against families with children. They were called on the carpet by 4 fair housing organizations, and then HUD brought charges against them. Supposedly, they're doing much better with that, and they're being monitored. And then, of course, the last example is engaging in blockbusting. So we usually have fun with that in the class. Ask folk, what do you think blockbusting is? It's kind of just what it sounds like. But it is for-profit offering to sell or rent someone's property by alleging that they need to be very aware that the land is changing hands. In other words, other groups of people are moving into the neighborhood and the current residents are moving out, better known as gentrification. But the bottom line is realtors guilty of that, and they basically will tell you, come on, let me go ahead and list your property, because if you don't hurry up and do it, it's not going to be worth anything. Those people are coming in here, you know, everything's about to fall apart here, your value's going to be gone. Their partner will go to the people moving in and say, boy, if I got a deal for you, come on over here and you need to look at this house. Strictly prohibited under the Fair Housing Act. As I said before, a lot of housing providers will tell us, well, you know, those fair housing laws, that's only for renting. It covers all real estate related transactions. So it covers sales, it covers mortgage lending, covers homeowners insurance. You'll be shocked at how premiums changed for similarly situated homes based on where they are. Appraisals certainly are covered. We see a lot of appraisal discrimination, all housing related transactions. And be clear that harassment, interference, intimidation, and coercion are strictly prohibited on their own under the Federal Fair Housing Act. So I talked about steering in that case in Orlando. Steering's strictly prohibited and mostly practiced by, it can be practiced by realtors, it can be practiced by lenders, steering you to a mortgage product that provides them with a better commission. But steering is strictly prohibited, and that's discouraging any person from inspecting, purchasing, or renting a property. And the way you discourage a purchaser, for example, is by exaggerating everything that's wrong with the area or the property they want to move into, and just not bothering to tell them about the more desirable features of the community. So steering is prohibited in a building or in an entire neighborhood. Probably the most obvious steering requirement under the law, and not the most obvious, but the most not obvious, is a requirement that people have no idea is there. And since we are in an automated world, everything is automated, it's very easy to do. But the law says you can't employ codes or other devices to segregate tenants or applicants if that segregation is based on one of those 7 protected characteristics. So we had a big case in the Miami Fair Housing Center where I came from to Atlanta over a decade ago. But large management company in Miami-Dade County actually had a person who worked there for 20 years and left, came straight to our office and said, I need to know, can I file a complaint, because I've been working here a long time. They send me to fair housing classes, but they clearly employ codes to identify tenants. I don't care whether you're moving in, you want something repaired, or they get ready to evict you. We can identify you. We know your race, because everybody of a certain race gets a certain code. We know people who have children. We know if you have a disability, definitely you get a certain code. So that was a big case against that management company, and needless to say, the management company lost it badly. So if you feel like you've been discriminated against, it's very, very, very important that you come to us, come to any of the other enforcement agencies with really, really good information. It is important that you be a good record keeper, and we train people. It is a great life skill to have. A lot of times people do have what appears to be a good complaint, but they can't tell us when and how things started. They can't identify who they talked to. They say, oh, his name was Jim, but I don't know if he was the manager or he was just, the maintenance guy that day. It's very important that you keep a good record of meetings that you have, phone calls, get specific information about people's names and titles. And of course, you don't sign anything unless you have someone to look at it first. And if you do sign something, you make sure that you have a copy of it. Of course, all the high-tech people will have theirs in the cloud or somewhere. If you're old like me, you've got an envelope or a folder or somewhere to throw it into. But you need to keep up with anything that you sign, particularly contracts and leases, because they dictate how the housing is supposed to operate. And oftentimes, they may be in violation of the law. So, Metro Fair Housing Services, we receive almost all of our complaints by phone. So our number is there, 404-524-0000. Of course, US HUD has a hotline for taking discrimination complaints. Atlanta Legal Aid Society we reference because a lot of times people call us, and many times it's about evictions or a contract matter. We do not practice law. We're not attorneys. We will refer you immediately to Georgia Legal Services or to Atlanta Legal Aid Society, in those instances. So your resources are there on the slide. The website for US HUD, for the Georgia Commission on Equal Opportunity, the Consumer Protection Finance Bureau. That's really for people who feel like they've been discriminated against in the lending space when they're typically trying to get a mortgage loan. The National Fair Housing Alliance, and of course the Department of Justice is at www.justice.gov. So I thank you for joining us today. That was a lot of information, but it is vital information. It is very important that you know your rights. So I would urge you to give us a call if you need to. And thank you very much for participating with us today.